Hey, thanks everyone for joining us again for another editorial board meeting. We're just continuing our conversation about policing reform and criminal justice reform. And today we're joined by Bexar County District Attorney Joe Gonzales, who I believe was elected in 2018, right, Joe?
That's correct.
That's right. One of the reform prosecutors that we saw in a series of elections across the country. We're also joined by Joe Gonzales's colleagues, Jamissa Jarman and Daryl Harris from the prosecutor's office. We've got publisher Mark Medici here, Gloria Padilla and Carrie Clack from the editorial board, Emily Eden, criminal justice reporter, and Scott Huddleston, who covers Bexar County, many other things. So thanks all for joining us. Joe, we've talked a lot in the past about criminal justice reform. I was wondering if you could outline, and usually those conversations have focused around bail reform, pretrial incarceration issues, nonviolent offenses, things of that nature. But I was wondering if you could outline some of the police reforms that you see as crucial for Bexar County. You wrote about this in an op-ed for us last week, and I'd like to hear what you think needs to happen when we talk about police reform and criminal justice reform.
Okay, well, thank you. First of all, thank you for inviting me. It's a pleasure to have an opportunity to explain what we're doing in the office. And you're right. I ran on a platform of criminal justice reform, and we've been doing that for the last year and a half. And I'm pleased to say we've had a good amount of success. And so, people have been talking about defunding the police, but when you think about it, the reforms that we've instituted is a form of defunding the police because it redistributes the resources away from incarceration and away from arrest. For example, the cite and release. Before COVID-19, before all this stay at home started, in just 9 months, we had over 2,000 people avoid getting arrested. So that means that instead of being handcuffed, instead of having to sit by in the backseat of a patrol car, instead of having to be taken down to the magistrate's office, they get a citation for them to show up later at our reentry center. And what we did was we saved the county over $1 million by doing that. Unfortunately, it slowed down during the pandemic. We hope that when we get past COVID-19, we can go back and cite and release will again be robust. So that's an example. Another one, as you've already mentioned, is our bail bond reform. We operate at the magistrate's office, and Daryl is here, our deputy chief of the criminal trial division. He's very active in the magistration process. I jokingly say he doesn't sleep because even when he's not at work, he's at work. And so he is very active in making sure that our prosecutors at the magistrate's office operate under the presumption of release to recommend PR bonds where appropriate, even when law enforcement doesn't agree, even in cases where the judges don't grant the PR bonds. We want to go on record as recommending PR bonds. Our declination policy, for example, the declination of marijuana possession less than an ounce, declination of possession of controlled substance less than 1/4 gram. While we know the studies show that that all races use drugs and at the same rate, people of color tend to get arrested and prosecuted a lot more. You have more Black people, more Hispanic people being arrested for simple possession of marijuana. And so that's another way that we've tried to get the police to divert away from arresting these individuals through the declination policy. Another one is the declination of the criminal trespass of the homeless. Again, that's not very popular with law enforcement because they have to deal with the business owners. But again, why are we wasting our time criminalizing the homeless? And so those are examples of things that we have done to try and defund the police. As far as police reform goes, we've instituted measures in our office to have a greater check on law enforcement activity. For example, under the previous administration, the elected DAs and their administrators could make the decision, and did make the decisions on their own whether or not to present a case to the grand jury that involved an officer-involved shooting. Almost immediately when I took office, I instructed that division to present everything to the grand jury, even on, as I said in my article, cases that may be a close call. Let's let the citizens of the grand jury, let's let the citizens of Bexar County decide whether or not there's probable cause to believe that a crime may have occurred. So that's one way that we've changed the way we do business. Another significant way is under the previous administrations, they would have what were called clearance reports or even a clearance letter. The previous administration had a 10-day clearance letter where an officer was involved in a shooting. Law enforcement would submit a preliminary report. And if the prosecutors thought that it was a justified shooting, for example, or it was a clear-cut case, let's say, then they were instructed to, or they were told that they could put the officer back on the street. I said, no more, we're not doing that. We're not making decisions about whether or not a shooting is justified until everything is in. We're not going to be party to allowing an officer to get back on the street unless we know whether or not he had a defense to a shooting. So those are two examples. But, you know, it continues to evolve. One of the things that we're talking about doing is creating a policy for our prosecutors where they themselves see any sort of police misconduct, especially when it has to do with race. If they see any kind of indication of racial disparity, they are to bring it to the attention of their chief and up to administration. I want to know whether or not there's anything that law enforcement is doing that is based on any kind of racial disparity. So those are examples of what we're doing to try and address the issue that we all see has been brought to the forefront in the last couple of weeks.
Joe, but given the relationship between the DA's office and the San Antonio Police Department, is your office the right agency to conduct these investigations that involve police officers? I mean, one day they may be your complaining witness in your case, and the next day they may be the target of your investigation.
Sure, that's a valid point. Unless and until there is some sort of funding that will handle these kinds of cases independently, this is the system that we have. But I will tell you that we make efforts to distance ourselves. I have contact all the time with Chief McManus, and he knows that I've got a job to do. What he and I have said is, you do your job and I do my job. We don't always agree, and we don't collaborate with each other in terms of deciding when or how to file a case. They bring a case to us, we review it, and we decide whether or not there's sufficient evidence to go forward, even where it involves a police officer. And we have done that. We have prosecuted members of law enforcement for different offenses, such as aggravated assault with a deadly weapon, tampering with evidence, and crimes of that nature. It's a very good point. But again, Gloria, let me point out, there isn't any special relationship with me and SAPOA. They didn't endorse me when I ran for office. They didn't even give me an interview in the general election. And so I'm not beholden to them, just like I'm not beholden to George Soros. I'm sure people think, well, they'd be curious to find out, where my supporters. That group has never called me and said, hey, I want you to do this. Just like SAPOA has never called me, SAPD, or anybody else said, we need you to do X, Y, Z. We are an independent agency, and we're going to maintain our autonomy.
How do you investigate a citizen's complaint about a police officer? I mean, most complaints usually have to go through the San Antonio Police Department to get to your office. How do you handle with somebody who's alleging that there's been some crime committed by a police officer? I'm not talking about an assault, some other case that would have been handled anyway, but like if they're complaining about the way a police officer did their job.
We have certainly some numbers that are accessible to the general public. 210-335-2311 is the general office number. Certainly a citizen can call and register a complaint. We have a website. Bexar County District Attorney's Office has a website where they can reach out to tell us about a complaint, we are not an investigating agency. Unfortunately, we don't have investigators that investigate cases. Our investigators are support for the trial divisions. They gather evidence, they prepare subpoenas and the like. But we certainly do want to take every one of those complaints very seriously, and we would welcome and invite people to call us, and we would try and get them to the right place. Again, you have that same issue. Well, if somebody complains about SAPD and we don't investigate SAPD, what do? Send it back to SAPD? We have to have some faith that law enforcement agencies want to weed out the bad cops. It doesn't do any good for Chief McManus to have bad cops in his department. It doesn't do any good for Sheriff Salazar to have a bad deputy in his department. They want to do something to ferret them out, because the large majority of them are trying to do a good job. And so they certainly, that's the way that we can handle a complaint. And that's the way we have been trying to handle these complaints.
Thank you.
There have been calls for you to reopen cases involving officer-involved shootings. So Marquise Jones, Charles Roundtree, Anthony Scott. You've declined those, to reopen those and reinvestigate. Can you explain your thoughts on each case and why you wouldn't want to look at these again? Or
Sure.
I realize two of them predate you, but why you wouldn't want to reopen this?
Okay, and what you said, I think you said it subconsciously, but that's part of the problem. When you said why you wouldn't want to look at these again, I have been looking at these on numerous occasions since I took office, and that's part of the problem with the narrative out in the public is people are using different verbs at different times. People are saying, why is the DA refusing to review these cases? It happened yesterday in your paper. There was a caption where underneath the caption, it said a day after the DA's office stated that he wouldn't review the cases. I have reviewed those cases on multiple occasions. One of those is Marquise Jones that was brought to my attention during the campaign. When we came into office, we sat down and conducted a full review of that case, because that's the one, again, that was brought to my attention. One of those three is a case that happened during my administration. I'm happy to discuss them one by one. It would probably take more than an hour to go through them, but I can generally tell you the reason that that we have reviewed those cases and right now decided not to reopen. And in my mind, reopening means giving it a new case number and preparing it to re-present to the grand jury, is because, number one, I didn't see anything wrong that the previous administrations did. They did what they were supposed to. One of those cases, Marquise Jones, they actually took to the grand jury, and the grand jury no-billed that case. We took Mr. Roundtree's case. Charles Roundtree was the victim of that shooting, the unintended victim of that shooting, by the way, and the grand jury no-billed that case. Those, I've been saying, are different than what happened in Minnesota, where in my mind that was nothing short of murder. It disturbs me now that we have a second case in Atlanta. I've seen the video. That's another disturbing incident where I'm not sure that that officer was justified in shooting at the man that was running away from him, and he points a taser gun on him. That's different to these instances. These instances, 2 of the 3 cases involve situations where the officer had to make a split-second decision to fire his weapon because he was in fear of his life. Just briefly on Charles Roundtree, the person that he was facing, the officer was facing, was a defendant by the name of Mr. Snowden, who stood up, and as he stood up, pulled a handgun. The handgun was ultimately found outside a bedroom window, and if you were to match the barrel of the handgun, it looks identical to what was seen in a still frame, which is what the officer saw. So the officer faced with a person that's pulling a gun on him, reacted because he was in fear of his life, shot him. And so Mr. Snowden takes a move to the right. Unfortunately, by doing that, puts Mr. Roundtree in the path of the bullet. And so that's how Mr. Roundtree ends up being shot, because it passes through the buttocks of Mr. Snowden and hits Mr. Roundtree. Charles Roundtree was an innocent bystander. He's just sitting there, but because Mr. Snowden walked in front of him, that's how he was hit. In the case of Marquise Jones, there were several witnesses, including 2 lay witnesses, that put a gun in Mr. Jones's hand. So that's another instance where the officer makes a decision to fire his weapon because he's in fear of his life. As a matter of fact, one of the late witnesses in her statement says, I thought I saw him point the gun at the officer. And so that's one of the considerations that we took in deciding not to represent that case. Again, remember, Charles and Marquise Jones, they actually presented it to a grand jury. Then the last case was one involving Mr. Scott. That's a situation where the officer was trying to effect an arrest. The subject, Mr. Scott, abruptly gets out of his vehicle, makes a quick turnaround, and has something in his hand that appears to the officer to be a weapon. Unfortunately, it turns out to be a cell phone. But he, according to the officer, moves in an aggressive manner and is pointing it somewhere in his chest area. So the officer reacts to that. There were 2 independent witnesses, 2 lay witnesses, who both corroborated the officer's testimony. And I think at least one of them said, it looked in my mind like he had a gun and he was about to shoot him. So again, that was a decision the previous administration made. They did not present that case to the grand jury, but we reviewed it, and it appeared based on all the evidence. And keep in mind, I have been debriefed by the investigators and the prosecutors that were involved in those cases, the ones that are still here. But in addition to that, I reviewed the evidence myself. I've reviewed the PowerPoints that were put together. I've reviewed some of the other evidence involved in these cases. So in my mind, there isn't, and I'm bound by the code of ethics. In addition to the law that requires that justice, that we seek justice, not to prosecute. And so based on that, those codes of ethics, there isn't anything that has been presented to me that would lead me to believe a grand jury would be, that would do something different. Now, let me say this. I invite anyone to come to our office and speak with us. If there is new evidence they want to present to us, I'm willing to hear them out. I'm willing to review whatever evidence they have. But nobody's done that. We tried to coordinate with a spokesman for the families. We haven't been able to sit down and have a visit. I, as late as this morning, tried to reach out to the attorney for the families of Marquise Jones and Charles Roundtree. I haven't heard back from him. I'm certainly willing to talk to the families. I would like to talk to them to explain to them why my decision thus far is not to reopen these cases and represent them to a grand jury.
Joe, on that note, is there anything that your office can do to increase transparency on these cases? Because obviously there's been some civil litigation regarding them. And so there is already some evidence out there in the court files in terms of police reports and things like that. Is there anything, but not the whole public doesn't have access to those files or to those court documents. Is there anything that you can do to release those documents to the public so that they can review this evidence yourself and sort of see where you're coming from?
Well, that's certainly something that we can consider doing. Again, that was one of the promises that I made when I ran for office, and that I'm trying to follow through on, which is transparency. We're trying to be as transparent as we can with everything we do. if there's a way that we can release evidence and documents, I certainly would consider doing that. For example, right now, let's talk about the situation with Charles Roundtree. They are in, the family is in the middle of a civil lawsuit. And so the problem would be in me releasing that information or any of that documentation that would compromise that lawsuit. Certainly, it would be possible to release the information or the documents and the videos and maybe even PowerPoints that we have on, for example, Marquise Jones to the public. But here's the danger in that, if you think about it. So let's say we release what we have and the general public has seen it. Remember, we have now 2 million people in Bexar County. So we release it, and then a month from now or 6 months from now, somebody comes with us with new evidence and we decide to represent it. And this time we have now indicted the case and we're ready to go to trial. There's an argument that we have tainted a potential jury pool, that now people have seen some of the evidence. So what may happen now is that may cause a change of venue, because the person that may ultimately be indicted cannot get a fair trial because people have already seen some of the evidence. So that's the argument against doing something like that. But to answer your question, I'm really sure there are things that we can do. In fact, one of the things that I'm thinking about doing is maybe we should have a press conference. Maybe we should invite the media to discuss the kinds of information we had in making the decisions that we're making right now. Because remember, nothing is entirely closed. I've never said, you know what they did, I'm not going to look at it. I have continued to review these cases. I did, for example, in the case of Marquise Jones, I did it when I first came into office. I've been continuing to review these cases in the last several weeks. I did it again last week, and I certainly am willing to continue to do that because I want justice. I want to make sure that the families know that we've done everything we can to ensure that we've done everything that we're supposed to. And so, sure, I'm open to doing that if we can do it again without compromising any of the family's interest. It could be that Mr. Roundtree's lawyer say, no, I don't want you to do that because I don't want it to affect the current lawsuit. Could be the city tells me that it's not a good idea, but I certainly am willing to consider doing things that would increase the transparency.
Joe, I wanted to get your thoughts on how you feel that the criminal justice system is functioning during the pandemic. And I know that Judge Rangel's order, I believe it takes effect today to resume some of the in-person hearings. But at the same time, you have to be concerned about the issue of due process for the defendants. And I know that there's still quite a ways from having jury trials again. So, and at the same time, there have probably been a lot of domestic violence cases. So can you speak to those issues and how you're dealing with that?
Sure. That's very good. And this has been a very frustrating time for us in the criminal justice system. It's been a very frightening time. We have an office of over 500 people. They are very nervous about having to come back to work. Most of our people have been able to function remotely, have been able to work from home, but there's a certain percentage that have not been able to do that very well, and they're going to ultimately have to come back to work. But I will tell everyone that can hear me, we have continued to work during this entire period. I sent people home to work from home probably the third week in March. And those people have continued to do that. The good thing is they've been able to chip away at the backlog because they've not been in trial. They've been able to work on reducing the backlog of intake, for example, that they have in their individual courts. They've been able to prepare for trials that are coming up later in the year. So I dare say that we should by now be very prepared when we get back to going to juries. Judge Rangel have talked and I have talked on numerous occasions administratively about when the time is right. We've been talking about late August, maybe early September. So we know that at some point we're going to have to deal with those cases that have been waiting on deck, let's say, for example, to use a baseball analogy, to go to trial. And sure, those people that are accused of crimes, especially the ones in jail, they want their due process, right? They've been sitting waiting to go to trial, but it doesn't do any good to hurry that up and bring a pool of people to come and expose them to the pandemic. So we have to be very careful to do that. One of the biggest concerns that you mentioned, Scott, is domestic violence. We know that there are some victims of domestic violence that have been sheltering in place with their abusers, and they shouldn't have to do that. They shouldn't have to make a decision. Do I put up with him or her continuing to assault me, especially if it's in front of my kids, or do I go out there in public and expose myself and my children to the pandemic? They shouldn't have to make that decision. We still have resources available. Our Family Justice Center has been open all this time. They can call us to seek a protective order. They can reach out to family members. That's what I've been saying. Those people that are sheltering in place with their abusers, please reach out to your family and your loved ones and your friends. We'll find some way of helping you. So it is a concern, Scott, that at some point we're going to have to go back and we're going to have to deal with the backlog of cases. But again, we've been working on trying to prepare for that. And again, everybody here in our office is very dedicated, and we're doing a good job trying to do as much as we can with the resources that we have.
Have you had a grand jury in place?
Oh yes, the whole time. Speaking of dedication, I want to give a shout out to the members of the grand jury. We're right now impaneling a new grand jury to start, I believe, if not June 1st, July 1st. I think it's June 1st. But we've had a grand jury that actually was held over because of the situation that we have. Both grand juries indicated they were willing to stay longer and continue to hear cases. And so they've been incredible. We've had to undertake extra measures. And for example, instead of using the grand jury room that's kind of confined, it's a small space, it's a big table, but still they were sitting next to each other. We put them in the courtrooms of the respective judges. The judges in the 227th and the 437th, I think it was their grand juries, they bend over backwards for the members of the grand jury. So I do want to say that I appreciate their commitment, because without the grand juries appearing and continuing to listen to these cases during the pandemic while everybody else is at home, they were doing their job. They would show up with their masks and they would distance, but they were doing their job. So yes, we've continued to present cases. I know we send a press release at the end of every week, and we average about 250 cases a week that we have gotten returns from the grand jury. So we've been, again, in full operation.
So how does that 250 cases a week, how does that compare to pre-pandemic? Are you keeping up with all the police? I mean, I would imagine that individual cases being filed is down because people aren't out and about as much, but are we keeping up with the caseload?
Yes, I think it's as far as the number of cases that have been filed during the pandemic, it depends on the kind of cases that you're talking about. For example, I hear that the property crimes are up. I mean, we, for example, going back to domestic violence, we heard that there was an increase of 18% of domestic violence calls. Well, that hasn't translated into an increase of cases filed in our office just yet. That doesn't mean that it's not coming, but so far we haven't seen a drastic increase of domestic violence cases. As far as other kinds of cases, we haven't seen a big increase. Again, going back to cite and release, when we first came into the office, what we noticed is the large majority of cases that were being filed, of the people that were arrested, were possession of marijuana cases. Well, because of my declination policy, that was reduced by, I think, 75 to 80%. So we know those cases are not being filed during this period of time. So we are keeping up with the cases that that have been filed, and it's about the same as pre-pandemic. So again, I don't think there is an increase of cases of people that are sitting in jail. And Jamisa and Daryl, you can correct me if this is incorrect, but I don't think there's an increase of people that are sitting in jail because of the pandemic. Otherwise, I think we hear about it from the sheriff's office.
So,
No, sir.
I was curious about your DWI cases. Are people drinking in place, or are they driving?
I think there's probably, from what I understand, while we were under the local executive orders from Judge Wolf and the mayor, I think we saw a reduction in the number of DWIs because they weren't out on the road. However, now that we're reopening Texas because of the governor's orders, now that we've relaxed the restrictions, there are some bars that are open, and I think we're now seeing an increase in DWI arrests again. My shout out to, I think there was one business owner that decided to shut again. That's great. I hope more people follow his lead. He's doing the right thing. We need to continue to be safe during this period.
Thank you.
Mr. Harris, were you going to say something about Joe's comment regarding people languishing in jail?
Well, just to comment and endorse it, we've looked at and trying to be consistent, hold in custody and fight for appropriate bond settings for violent offenders. Those things that we can resolve and move, we've tried to pay attention to. The jail court dockets have continued to thrive both virtually, and we're looking at increasing that docket, and then hone in on the right persons. And to also echo the weekend that we started to open up, it was a noticeable uptick in DWIs. Now that might have been pent up just because the prior month and a half, 45 days, people were shut down. Intox mans, intox assaults have continued to happen at a consistent pace as people move around, and it's just, we address it, it just changes the way we do so.
Joe, I'm just curious, but Bexar County does not have a bail reform order that parallels what Harris County did. I know that your office has instituted a number of reforms to try to mimic that practice that we've seen in Harris County. But how important is it to you to see the judiciary enact an order similar to that parallels what's happening in Harris County? And how would that potentially change bail hearings?
I think it's very important, and I would urge my colleagues on the bench to consider doing that, to consider meeting and coming up with some sort of an order that would mimic what Harris County did. And keep in mind, a lot of what Harris County did was as a result of that federal lawsuit. And that's certainly something that's potentially on the horizon. So I think, and let me tell you that there are members of the judiciary that are aware of that and that are trying to be progressive and trying to come up with ideas. But it takes all of them together. The difference is, while we have a group of 13 administrators and we all work together, the courts, the county courts, there are 15 county courts, criminal county courts, and then you have the 10 criminal district courts. And so they all have to come together to reach an agreement. And while I know they've been working at it, they haven't been able to do it just yet. But I would encourage them to continue to work together, to continue to engage in a dialogue, and to come up with some sort of a plan that mimics what Harris County is doing. Because I think at some point, if they don't do it on their own, they're going to be forced to do it.
You think that there's a potential for a federal lawsuit against bail practices here in Bexar County?
Oh yeah, absolutely.
Is there, are any groups, do you know of any groups that are considering such action?
I don't specifically know of any particular groups that are thinking about doing it, but I can imagine that they're, you know, when you think about groups like LULAC, you know, even the Democratic Party, you know, there are probably groups out there that are concerned about this. You know, TOP comes to mind. Move Texas. There's certainly groups out there that have been talking about alternatives to mass incarceration, bail reform. So there's certainly plenty of groups out there that can initiate the lawsuit.
Would your office then have to defend the bail practices that you actually want to reform?
I don't know that we would. I mean, I guess that's more a question from the chief of my civil division. But I suppose that if a particular person was a defendant, for example, if the county judge was a defendant, it might be incumbent upon us to defend the judge. It may be a situation where we may think it may be appropriate to outsource that lawsuit to a civil firm, but certainly it's possible.
I'll ask one last question, then I'll mute myself here. But I'm just curious to hear where you think where you see the greatest racial disparities in our criminal justice system.
You know, I've thought about that, and I think that you know, there's all kinds of disparities from the point that law enforcement deals with members of the public to all the way up to sentencing. And so every member of the the criminal justice system could learn from this experience and attempt to do things better. I've been talking about the concept of implicit bias, where you treat people differently and you don't even realize that. And remember that the large majority of my legal career was as a defense lawyer. And there were times when I talked about this to jury panels, and I would ask questions like, how many of you unconsciously will cross the street when you see a member of a minority walking the other direction, especially at night? You know, you'd be surprised about how many times people didn't even think that they did that. And that's what I'm saying is people treat people differently. Look, we have to acknowledge that there is racism in everything, including law enforcement. There is probably some racism. In fact, I'll go further and say that there is racism at some levels and some percentage in the criminal justice system. But the first thing we need to do is recognize that, and so we need to try and do something about it. We, as prosecutors, for example, we need to recognize that sometimes we engage in implicit bias and don't even realize that. That's one of the reasons that I'm trying to learn about that. I sent a couple of people up to a conference at Stanford earlier in the year to try and learn about how we can better recognize implicit bias, how we can recognize when law enforcement treats people unfairly so that we can do something about it. And then also try and educate the courts about that. I think the judges need to be more attuned to that, and certainly juries when they consider sentencing. When you talk about asking for jail time or prison as opposed to probation, do you take into account the person's background and the reason that they committed the crime? And sometimes race has something to do with it, because people of color sometimes don't have the same opportunities as other people do, as white people, I guess is the easiest way to say it. And so we have to recognize that in how we do business. And I'm hoping that this is the one thing that we all learn from this, but we all have to be willing to learn. And that's something I said at the end of my editorial the other day, or the op-ed, the district attorney's offices all over the country need to recognize that we have to do a better job, that we have to recognize that we have a problem and we have to do something about it now.
So would you care to compare the Bexar County Sheriff's Office with the San Antonio Police Department in terms of the issues of police reform and cultural sensitivity to the things that we've been talking about? Because the SAPD issues have basically broken out into three parts. One, what can be changed administratively right away. Two, what can be changed through changes in state law. And three, what could be changed through the police union agreement. So can you kind of walk me through that issue of how you would compare the sheriff's office on that same plane?
I think both offices or departments are trying to recognize they have problems and trying to do what they can. You hear more about SAPD. These three cases that everybody's talking about are SAPD cases, but that's because there are more officers from SAPD on the street. I think at any one time we may have 75% of the cases that come from SAPD, for example. So you hear more about them. But again, I believe the sheriff is trying to weed out the bad deputies, just like the chief is trying to weed out and do something about the bad officers. And by the way, you know, that we haven't talked about it specifically, but I will tell you that I think a big problem is the police unions and their arbitration system. There have been some instances where bad cops cannot stay fired, and that's a problem for us, because I know at least one instance where we have put that officer on what's called a permanent list, where we will not sponsor him because we believe that he's got serious credibility issues. And so that's a big problem that they're going to have to deal with. I know supposed contract is coming up next year, and the city council is talking about that. At some point, I'm sure the deputy sheriffs, their contract, their union will come up, and so they've got to deal with that. But the answer, Scott, is I think that both departments are again, the top brass, the sheriff and the chief, are trying to do what they can to identify the problem, do something about it, but it's not going to happen overnight.
When you say, sorry.
Oh, I think we're going to ask the same question. So when you're talking about you won't sponsor a police officer that's on this permanent list, does that mean you won't take a case where they're the complaint or they're the investigating officer? Well,
I mean, what will happen is we may end up accepting the case. We may end up filing it because it may take some time by the time the prosecutors realize that this is an officer we won't sponsor. But at some point, we're going to realize, for example, if this, let's say we're talking about an officer who is on that permanent list and he's the one that makes the stop, he's the one that makes the arrest, and let's say that he's critical to the case, what we may end up doing is having to dismiss the case, because we're not going to put that officer on the stand if he's on that list. So that's right. It might jeopardize that case if we can't make it without that officer. And by the way, I'm sorry.
So how many officers do you have on that list?
We have a handful of officers on that list. I know of one officer right now that we intend to notify Chief McManus about this status. And what they do is is up to them. But I can tell you right now that I'm talking about one officer in particular. Now, when you think about, they have 2,500 officers on the street, and if only one officer comes to mind, that's pretty good. That's a pretty good ratio. That's not to say that can't happen in the future, or maybe there are some officers out there that are on the perm list that I'm not aware of. But that's what we have a conviction integrity unit, and it's their job to maintain that list and continually update it. And so they're the ones that are more involved in it.
Let me just play devil's advocate here just for a second. So on one hand, you're saying that there are aspects to the union contract that because around disciplinary issues that can undermine prosecutions for you all because there are credibility issues around these officers, right? But on the other hand, you're saying there's only one officer on the list. So I don't see how those two dynamics really square? I mean, one officer out of 2,500 to me says there's not that big of a problem.
Well, it may be that while there is one officer on the permanent list, that doesn't mean that there are other officers that could potentially be put on that list, or that we don't believe should be making cases.
Yeah.
So that permanent list is just one where we believe that we will not sponsor as a witness. So
I guess my question is really, how pervasive are these disciplinary issues in terms of undermining prosecutions? You know, because that's an important question I think the public should have a sense of as we go into these contract negotiations.
right. And that's not an answer I can give you right now. I guess we could do some research and find out how. I don't know that it's a real problem. It is a problem, but I don't think it's a large percentage of our cases. I mean, we all have heard about these cases. The one that comes to mind, everybody's heard about is the one with the sandwich that contained the feces. I mean, that's a horrible case, right? You wouldn't want something like that continuing to come to continue to be a problem. That's an example of an officer that we think has some issues, but there are others. So again, there are a handful that come to mind, but I don't think if you're using the term pervasive, I don't think it's pervasive. In other words, I don't think it's a large majority of either SAPD or the Bexar County Sheriff's Office.
Joe, I'm assuming we're talking about the Brady List, correct?
Well, that's a little different. Brady is basically an obligation to disclose anything that's exculpatory, not necessarily a person that we don't sponsor to testify, but there can be anything that would require Brady information. But it's generally sometimes called it's more a disclosure list than a Brady list, although that phrase has been used before. We tend to shy away from calling it a Brady list. It's more, again, we call it a disclosure list.
Okay, perfect. That's good to know. On that note, I know a lot of media organizations have requested those lists from DA's office throughout Texas, and they've had trouble getting them, even though, at least as far as I'm concerned, the Supreme Court said, that information has to be released to the prosecutors and as such has to be released to the public. I could be wrong on that interpretation. But on that note, would you consider releasing the Brady List to the public?
We've been talking about it, and that's certainly something that I would consider doing that. We haven't made a final decision yet, but certainly there's an argument to be made that it would be in the interest of the public to have that list released. So yes, we are talking about it, and hopefully I'll make a decision soon about it. But we have been talking about it, and yes, I'm considering doing that. And keep in mind, I said consider doing that. Okay, haven't made a decision yet.
And if I can go back to one thing, this is Jamisa. One of the things also we're trying to do to help with the jail population is in the appropriate cases, if it's a nonviolent offense, the person's not a threat to the victim or the community, we recommend PR bonds to try to help move those along. And sometimes we can agree with the public defender's office to kind of help move those cases. So I just wanted to go back and add that. I think Daryl talked a little bit about how we address the jail list, but that is something else that we're doing at the magistrate level.
Just speaking of the public defender, have you all been, have you seen any changes with the public defender presence at bail hearings? Do you strike you as, I mean, you're coming from a prosecutorial perspective, obviously, but do they strike you as more equitable having a defense counsel there to advocate on the other side? Does it make things clearer for everyone about what is happening?
I think it does. I think having the public defender's office there with the DA, it's more of an equitable situation because the person is being represented, they're being talked to beforehand, so the public defender is able to get other information that the judge may not have, and they can advocate on the behalf of their client. And then with the prosecutor, there, we can advocate for the state, looking at the criminal history and what are the other factors that there may be that we need to make the judge aware of so that the judge can make a better decision.
Hey, Joe, it's Jamissa and Daryl, thanks for your time. I want to ask this question around kind of implicit racism or this undercurrent of racism. I think that in the last month, it's probably the topic that has interested me the most. And I think this whole notion of being placed under arrest, specifically Black men, unarmed Black men, and this resistance of being placed under arrest, that is deep-seated, and it comes from a fear of being placed under arrest by an arresting officer. How do you begin to quantify how, from a DA's office perspective, how this fear of being placed under arrest when maybe someone has committed a crime, but this whole notion of resisting arrest, we saw it really displayed in the Rayshard Brooks case in Atlanta, where it seemed to be a very calm case, and then it escalated rapidly. And so this whole notion of kind of the place of racism within inside of the arrest process, how are you guys dealing with that? How do you deal with that when these cases come to you, when there's somewhat of a knowledge of this implicit or undercurrent of racism that exists in a small way, not a large way? I'm just curious how you guys deal with it, and how do you start to try to solve for it?
Well, that's the question. It's hard to, first of all, recognize that it exists, but then it's like you say, it's hard to quantify, and it's hard to know. It's kind of like COVID-19. You know it's out there, but you can't see it, you can't smell it, but you know it's there. And so that's the big challenge for us is trying to educate our prosecutors to recognize it when we can, and to try and deal with it. One of the ways that we can deal with it is when we recognize that maybe a reason a suspect, or ultimately then a defendant, if the case is filed, resists arrest, is because maybe he really harbors that fear or belief that he's not going to be treated fairly, and he panics and he overreacts. And then there's different levels. Pulling away from an officer or pushing at an officer is different than fighting with the officer or trying to take the officer's weapon. So we try and look at the facts and circumstances, and then make the offer based on that. But we do, I think, a lot of us, and I know I over the years have seen examples of where at least you would suspect that there was some level of racism on the part of the arresting officer. But how do you prove that? It was frustrating for me as a defense lawyer trying to convince the prosecutor that the cop was if not an outward racist, not treating a Black or Hispanic person like he would a non-Hispanic or Black person. It's hard to convince a prosecutor. But it's just something that we have to recognize that it can exist. And so the more we can do to educate ourselves, the better off we are. By the way, you mentioned, Josh, about the perm list. We actually have 16 officers on that perm list, so it's more than a handful. But again, I still don't think that's pervasive. It's enough that causes us concern, and so that's the number that we have today.
That's 16
If
across all law enforcement.
Yes,
Not just SAPD. Yeah.
correct.
Yes.
Yeah, it might not, as you said, it might not be pervasive, but there's a big gap between 1 and 16, of course. So
That's correct. That's correct.
I have one last question, but I don't need to take the last question if someone else wants to chime in. Okay, my last question is, we hear a lot of discussion about defund the police, and you pointed a little bit towards this in your op-ed. When you hear that phrase, how do you interpret that, and what does that mean to you?
to me, an effective defunding is to reallocate resources in a police department's budget. It doesn't do any good if the people that, and I know some people early on were talking about defunding the police to do like, I think some small jurisdiction, a piece somewhere, I think it was New Haven, or they basically fired their police department, and I think there were only 400 there, and then they restarted. That would be near impossible to do with a number. I think they're about 2,500 on the street in SAPD, if I'm accurate. Can you imagine firing 2,500 police officers and starting from scratch? It would be a very difficult task. What I think is more effective is to look at the police officers' budget, police department's budget, and see what kind of resources they can reallocate to education, to training, to things on topics such as homelessness, such as mental health, such as substance abuse. And I think that would go a long way in trying to reduce the issues that we see today, and go a long way in improving police reform. So that's what I think effective defunding can do. And again, we're trying to do our version of it with the reform programs that we have. But it's not an easy solve. It's going to take everybody working together. But I do think that it's worth talking about what the police department's budget can look like with reallocating these resources.
Great. Any other questions out there?
I thought of one last one, if you don't mind.
Yeah, of course.
Joe, I don't know if this would even be legal, but I think a big problem that exists in the community is that they don't necessarily understand how the grand jury process works. And so and because the grand jury process is secretive, they don't know all of the evidence that is presented, and they don't know, in some cases, even if a case is presented. To that note, is there anything you can do with officer-involved shootings separate from a grand jury, such as like a review board that would put public members on these boards and would allow them to speak publicly about what they reviewed and what they thought about a case, to increase transparency about among at least some public members about what's going on in these cases and their decision process?
Yes, Emily, and we've actually been talking about that. And keep in mind, I've only been in office. I say only. It's been a year and a half, but the first year we spent trying to initiate and to implement our reforms. And then, of course, the pandemic occurred. But we've been talking for a while now about creating a citizens advisory review board, having members of the public come and visit with us about officer-involved shootings and cases where there are issues of race relations, so that we can get input from members of the community. I've been trying to be real careful about not talking about anything that happens inside of a grand jury, because it's actually against the law for me to do that. I can't tell you what happened inside a grand jury because it is secret. But that doesn't mean that we can't share the types of evidence that we have in a case. That's why I talked a little bit about what happened in these three shootings involving these officers. That is separate and apart, like you say, from what happened in the grand jury. But certainly, there are things that we can do. One of the things that we're continuing to talk about is how we can do our job better, how we can be more transparent. And that's certainly one of those ways, is bringing people from different segments of the community to come in and visit with us about their concerns, so that they can go back to their communities and explain to them how the process works.
That was a great last question, Emily. Joe, thanks for joining us. Jamisa, Daryl, thanks again for finding the time to speak with us. We'll continue these conversations, and everyone have a great day. Stay safe out there.